Welcome back, everyone, to OpenLine. We are talking about elder law, elder care law. And we have with us Barbara Boone McGinnis and Chris Johnson, both with Takis McGinnis. And several calls. So let's go back to the phones. Let's go to Taylor. Then we'll go to David. But Taylor, what's on your mind?
Okay. Ben, thanks for the show, and thanks to your guests for showing up tonight. I've got a question I hope is not too difficult. I'm thinking about having prepared a revocable living trust to put my home place in, and I'm not sure. Obviously, there's costs of the attorneys to prepare this, but I don't know what the procedure is beyond that. If there are filing fees that one has to pay, or transfer fees, or what is required once you have the documents done in this state. So I appreciate any information possible. Thank you.
Taylor, thank you. That's a great question.
It is a great question. It's a very common estate plan. There are other fees other than the attorney fees, but they're fairly nominal. To transfer a home to a revocable trust, there's a deed. So we all have a deed to our house. It gets usually we would convey from the individuals to the trustee of the revocable trust via a quitclaim deed, and that's recorded without transfer taxes but with recording fees. So it's a nominal charge. There is an extra step, but not a lot of extra money involved.
And tell us what a revocable trust is, why it would be a good idea. I guess go through that information.
I kind of skipped that part.
For those, I mean, I'm sure Taylor already knows. He's thinking about it. You're saying it's not that expensive. You could go in, the attorney's fees, there's some other nominal fees, but it's not that expensive if he's thinking about it. But tell us, is it a good idea? Why would you even need one of these things, a revocable trust for a home?
Absolutely. So a revocable trust is a great way for probate avoidance, and what you do is you set up a legal entity. That's really what the trust is. It's a legal entity that can hold property, and so you establish the trust. You go through the 5 steps of the trust creation of the trust process: the creation, the tax recognition, the funding, and then you're left with administration and then distributions when the trust is ready to pay out. So probably at his passing is when it'll be set up and his home will be transferred to who it needs to be transferred to. What that does is it prevents having to go to probate and go into court, have probate open, and then having judicial oversight over the administration of your estate. A great aspect of that is the privacy. When you open probate, you file a petition requesting to open probate, you have to put the heirs on that document. You put their names and address, and you put the estimated value of the estate, and so you can put a target on people's back for those that are out there up to no good and mischievous. People want to part people from their money, unfortunately, in our society, and we want to be very careful about that. And the trust funding process gets to do that privately, and so it's very good in interfamilial situations where it's just the family. I always say inherent in trust planning is just that, it's trust, and so I trust that my trustee is going to do their job and going to do it appropriately because it's done outside that spotlight of judicial scrutiny. But it is going to be tax neutral. There are no tax advantages to doing a revocable living trust, whereas with an irrevocable trust you can talk about some things, but with the revocable trust, really what you're looking at is avoiding court costs, avoiding attorney's fees, and keeping everything private. And I really think that privacy is a key aspect of it.
And to really dive into this, what's an example of when somebody maybe thinks they need a revocable trust and they really don't? Is there an example like that? I mean, somebody's doing it and it's not what they need to be doing.
Here's an example I know of that I always talk to my clients and I say, listen, we're looking for the right fit for you. There is no cookie cutter approach, hey, this is what we do, everyone who comes in, you're going to get a revocable trust. every once in a while, maybe there's an unsupported elder and they don't have someone that they trust enough to serve as the trustee after their passing, or maybe they do know people, but they don't have the requisite integrity to serve in that position. I always say with a trustee, they need to have two things. They need to have integrity and they need to be good at math, because they're going to have to track all of this. And so there are clients out there who say, I want my estate to pass with judicial scrutiny. I want to make sure the court's keeping an eye on things and making sure everything goes as it should, because I don't trust that I have people in my lives to make that happen without that. And that's one example.
Okay, interesting.
It would probably be a fairly rare occurrence that a revocable trust would just be the wrong thing to do. It may not be the best thing for you, but for it to really be wrong, because it is so neutral in terms of taxes and transparency and ownership. I mean, if you decided to put your house in a revocable trust, it's still just your house,
right?
You know, and it would have no impact on your tax basis or on your, if you were an older person and you had the tax freeze or the tax relief, it wouldn't affect that. It wouldn't affect your insurability of your home. So it would be a fairly rare occurrence that it was just wrong. One of the other things about probate avoidance, probate in Tennessee is, you know, it's fairly easy process. We have some great court systems, but it is still a hassle factor, and people probably would rather avoid hassle if they could. And I say a revocable trust helps families avoid the hassle of probate later in life. It's just time consuming.
Okay, interesting. Taylor, thank you for that question. And I hope that answers your question. Let's go to David. Hello, David.
Hey, thanks for taking the call, Ben.
Yes, sir. What's on your mind?
Well, I got a couple of things real quick. I've got a power of attorney over my mother. She's in a nursing home. I paid for that power of attorney, so I like to pay for, get what I pay for. Apparently, power of attorneys don't really mean that much. If she gets so much money in her account at the nursing home, $2,000, she gets above that, then they got to take that $2,000 and send it, but they're sending it to Dad, and Dad's been dead. Now they haven't been sending it because he's dead now. He died about 3 years ago. They won't send it to me, even though I've got the power of attorney. Now, it's not so much I want the money. Her money goes into her bank account, and that's where everything goes and stays and collects. It pays her bills. The money in her account at the nursing home takes care of what she needs. But they seem to have a problem releasing that to me so I can put it in her bank account. I even told them I'd give them the routing number, the bank account. If you want to just put it in there yourself, it didn't matter to me. But they refuse to do this, and I'm kind of thinking, a lot of places I've been to with a power of attorney, it doesn't mean much. And, I paid over $600 for an attorney to do this power of attorney for me. And the Social Security, they said they don't recognize it. The government don't recognize it. The Army doesn't recognize it. So the nursing home will not take care of this as far as when she gets over in her account.
How often does that happen? How often does she get over? Is it like every month?
No. It's probably every 6-7 months, because it collects little by little.
Right.
But the last time this happened, they didn't send it, and I asked them about it, and they said it's because they went by Dad's income and everything and what they had together. And even though I had the power of attorney, apparently it didn't mean that much. They were basically, I put her in there with the power of attorney, but they used him to get her in there with his income and all.
Right. All right, so your question's about power of attorney and how much, and this situation. I mean, should the nursing home be going around you like that, in your opinion?
I've got a medical and financial power of attorney over everything. They have to ask me for everything that's got to be done, and I'm having a little bit of trouble, getting them to play along. And I'm thinking I just wasted my money with a power of attorney.
All right, well, let's talk about that. I appreciate that. All right, let's take the call here. What do you think?
Well, there's several different ways that you can have legal authority to act for another person, and that's what a durable power of attorney is. It is one way to have legal authority to make decisions for another person. A healthcare power of attorney obviously is specific for medical decisions, but there are other ways, and obviously, without asking him a lot of detailed questions, it sounds like there's a possibility that there's a rep payee status involved too. And so a representative payee status is a designation made by the Social Security Department, and it would have control over Social Security income of an individual. So our government does not recognize civilian powers of attorney for almost anything. It doesn't work for VA planning. It doesn't work for Social Security interactions. You have to go through their system of establishing yourself as a fiduciary or getting legal authority over another person. So representative payee works for Social Security income. So if the facility that mom is living in is named the representative payee of her Social Security check, her Social Security check actually goes into an account there. They're responsible for that money in seeing how it pays towards her. With the $2,000 limit, makes me think there's TennCare involved. So they're responsible for making sure the income is used to pay towards her care needs. And really there would be, I don't know what the circumstances would be for releasing that money to a power of attorney, because they have to account to Social Security where the money went.
So what should he have done differently, or what can he do?
Well, I think a clear understanding, one, a power of attorney is it's still an important document to have. It still avoids conservatorships. The authority that you have is limited to the express powers that are identified in the document. Probably an understanding of who's representative payee, and if he wants to control that Social Security income, does he petition Social Security to become that representative for his mother?
So that's another step.
That's another step.
Yeah. Okay. What do you think? Is there anything you want to add there?
No, I think where I think the missing link was probably someone sitting down and explaining the process to him a little more clearly. Again, it's another very complex process, and there weren't any huge red flags in that other than, I think, not understanding these different mechanisms. And that's one of the problems in government benefits, is you have different rules. And as Barbara mentioned with the VA, they won't recognize just a regular civilian power of attorney. You have to file their special form. They have a 2122 Alpha that assigns you as the power of attorney, and you need to know those things and understand which benefit are we talking about, what is the procedures and criteria to get those powers established with that organization. And that's the biggest key, is understanding the interplay of all these different documents, all these different legal beings.
Well, that is interesting. I mean, I would think if you got a power of attorney over their finances, that money that comes to them, you would have, I guess, control over or whatever. But you're saying there's some that just don't recognize it, some governmental.
Right.
That's
All
correct.
Right.
Well, there you go. There you go, David. That's interesting. Let's go to Shayna. Hello, Shayna.
Hi.
What's on your mind? Thanks for calling in.
Thank you too. Actually, all of the other callers have asked good questions similar to what I have. I live with my dad and take care of him in his home. And there's a brother, Timothy, in Virginia, that wanted to be the power of attorney. I didn't understand that, but for legal reasons, he's the power of attorney, the first name on those documents, and I'm the second. And there's this other brother, Walter. He's the medical power of attorney, but I do all the work. I do everything, the paperwork, correspondence, everything, physically, caregiver. Now I'm running into, like going to the bank. They didn't want me, although they're used to me and know my face and everything, and when my dad was able, he could come in. But they want me to my name is not like the first person on the power of attorney paperwork that I showed them.
Right.
So they said I can't come in to put my name or do things without my dad,
Right.
even if he's not able to physically. So I'm running into those kind of problems. So I don't know, should I, or how can you ask Social Security to be the representative payee?
Well, first of all, how do your brothers feel about changing it? Have you talked to your brothers about changing it?
Well, no, one of them is sort of nonchalant. It really doesn't matter. The other is more of a, let me get back with you and we'll discuss it, but just sort of stays busy. Neither one of them said, like, no, don't change anything.
Okay.
But it's hard to tie them down. In the meantime, I'm still, doing everything.
Yeah, you're there on the front lines doing all this. All right, Shana, thank you for that. What do you think about the? Or do you have anything else? Do you want to say something else?
Just how what you all just said, a power of attorney sort of doesn't sound like it means much, just so that I stop getting encumbered so much now, because my dad's not able to go in or talk because of the Alzheimer's and tell people it's okay to talk with her. I'm just not sure how to proceed, but it's becoming more and more problems.
Okay. All right, let's talk about that. Shana, thank you. All right, what does Shana need to do here?
I think it's a great example of some things that we talk to families about a lot. When they're going about the process of choosing their agent, their attorney in fact, I have a lot of parents who think, well, I need to name my oldest son because that's the right thing to do in their mind. And it's, no, you need to name the person that is going to be available and is willing and is going to be able to do these things for you. Being a power of attorney is not an honor, it's not a treat, it's a job. And it sounds like she's doing a lot of the job already. So how you pick your agents, you need to pick wisely. Yes, they need to be trustworthy. Okay with math, at least let's try not to bounce any checks, but that they're there to do the job. The people that are named as primary agents, the two brothers, and she's what we would call the successor agent. So if these people were unable or unwilling to continue to function, she would be there to step in. Very important, good planning to have an A team and a B team, a backup plan, good idea. It's entirely possible that these primary agents could delegate authority to her to get some of the things done that she's trying to do.
And that's what she maybe needs to focus on.
Yeah.
She doesn't need to ask, she needs to say, we need, and how do you do that? Through an attorney? I guess an attorney just redraws some things up.
Yeah.
But it sounds like that's the situation she's in. She needs to get that done.
Yeah.
Delegate, amend, I guess, the current power of attorney and delegate that authority to her.
Right.
What do you want to add to that?
And I think it goes to two things. Along with David, she presents where you want a comprehensive plan and approach. They have this one document, and this one document isn't doing what they want it to do, and they're frustrated. And I understand, I sympathize with their frustration, because it is very frustrating when you meet with an attorney and feel like, I've got this document, this is going to solve all our woes, and it's falling short of that. And it's falling short of that because I think the complexity of what they're going through hasn't been explained to them. I'm hearing with Shana that we may have a capacity problem with Dad, and that perhaps he can't re-execute documents, and that would be an interesting call to see where he is at. And then she looks at, do we need to file for a conservatorship? And a conservatorship would then trump the power of attorney, would essentially say, listen, I'm petitioning the court and saying that this person can no longer function, and that I need to be, or whoever the petitioner is that's asking to have that control, I need to make those decisions for them. And that would be kind of the option of last resort. That comes with it great expense. It can cause family consternation. It's a difficult process, you are truly stripping an individual of their rights. And it is a very involved process the courts take very seriously.
And no one wants that. I mean, she's dealing with a father who has Alzheimer's. I mean,
Right.
that's the main thing she needs to be worrying about.
Right.
And she just wants to go to the bank and be able to, it sounds to me like, pay some bills or withdraw some basic money. And she doesn't need some protracted
Or maybe,
battle.
or maybe just an explanation to the brothers about what it is she needs to be done, because so much banking happens online now anyway. I mean, if it's some automatic drafts for bill paying, even if it's cutting her a check each month for groceries, you know,
Yeah.
maybe a family management focused meeting could help them.
I hope, if you're caring for your father with Alzheimer's, I hope the brothers can tone down their busyness and help you get to the bottom of what you need. But thank you for calling in, Shayna. Thank you. All right, so we're going to take a break. If you want to call in, there's the number, 615-737-PLUS, 615-737-7587. What is your situation or a question? Let us know. Take a break. Be back right after this.